Hi, good morning, everybody. I'm an attorney. My name is Romy Jurado. The name of our law firm is called Jurado and Associates. We are a law firm that does different areas of law. We do real estate, we do immigration, probate, litigation, estate planning, and trademarks all over the state of Florida. Today's class, I'm going to talk about foreign investment in the U.S., and I'm going to try to answer all of your questions. Please feel free to put them in the chat or in the Q&A so that I can answer as I go. The first thing I will do is start with sharing my screen. Give me just 1 second. Okay. Well, everybody, if everybody can see, I hope so. If not, just put it in the chat. Again, that's my firm. We're Jurado and Associates, and today's class deals with how to work with foreign nationals to buy real estate in Florida. So the Sunshine State, as we all know, has been home to a large number of immigrants or people that just want to invest here because Florida is a favorite destination for foreigners. Some foreigners end up staying here. Some foreigners decide to just simply have their investment here and go back and forth. It is very important for the foreigners to understand the different ramifications that are imposed either by the IRS, certain regulations, or Florida itself. Now, starting July 1st, we're going to have certain other restrictions that are going to apply for investors buying properties in Florida, especially those of certain countries. And I will, talk about that. One thing to highlight is the fact that you have real estate in Florida does not mean you have the ability to work in Florida, okay? So just because you have properties, many properties, you do not have the ability to work here. If you want to work here, then you need to apply for either a work visa or an investment visa. And the great thing is you can sometimes use the properties that you've acquired and purchased in order to apply for those visas. First thing that I like to inform all of my foreign clients, it's about financing. A lot of people foreigners are used to buying everything cash, especially in South America. And they don't understand that, sometimes buying properties with other people's monies, in this case, the bank, could actually be very beneficial for them, for their financial status, because instead of just buying one property, now they're able to buy 3 properties with the same amount of money. So in my experience, it's actually easier for a foreigner to obtain financing than it is for a U.S. person. When it's a U.S. person, they will check your credit score, they'll check your work history, they'll check many more things, your taxes, because it's all documents that are available for them. When you're dealing with a foreigner, most of the time they require financials prepared by their CPA or their accountant abroad, and then we're good to go. So buying with cash, to me, is something really important that the foreigners need to understand that buying with credit. It's something really important that they need to understand that it's available for them because it's actually going to help them buy more properties. Instead of just buying one house, they can buy 4 houses with the same amount of money. Of course, you can work with your preferred lender or your mortgage broker that, a mortgage provider that's familiar with working with foreigners can really be beneficial. They can pay interest. And one thing the foreigners don't know is that here we can amortize over 30 years. In a lot of countries, for example, where I'm from in Peru, the maximum you can get a loan for a house is going to be 8 years, 5 years. Whereas here you can amortize over 30 years. So it comes out, pretty good. And then if you buy a good location, and you guys realtors, you would know that, lady realtors, you can show them a good location where they will profit from the rent. So essentially the property is getting paid by itself and they're just simply paying out the mortgage from it, paying out the maintenance from it. And then at the end, the properties appreciate in value, especially in Florida. And if they do go down a little bit in value, eventually they're going to come up because everybody wants to live in Florida, especially South Florida. So properties are always appraising in value, and that is where the real earning comes in. Not so much in the rent that you make, from my experience, but in the appreciation in value. It's an investment. So it's really something fantastic. And that's what I like to talk to my foreign clients about, that investing in Florida can be beneficial, especially if you do it through financing. So also, there's different laws that I was mentioning that apply that the foreigner needs to be aware of when investing in Florida. We're going to talk about FIRPTA, which is it's a special withholding that applies to people that foreigners that buy property in any state, but in Florida it applies. We're going to talk about inheritance taxes, something that they need to be aware about. Formation of entities for legal and liability purposes. We're going to talk about title insurance, which is something that only exists here in the United States, and the restrictions for certain foreigners that are going to come into effect on July 1st that we should all be aware of. So FIRPTA, what is FIRPTA? So FIRPTA, it's a legislation that was done and it stands for Real Property, it's for Foreign Investment and Real Property Act. So before, in the good old days, foreigners were able to buy real estate, sell it for a big profit, and then they would just say bye-bye. And nobody filed a tax return, so the IRS didn't get paid on any, on any taxes due for the sale of the property. So in order to avoid that, to prevent that actually, the IRS instituted this regulation, which is FIRPTA, the Foreign Investment and Real Property Act, which effectively is not a taxation, it's a withholding. And what happens is that the closing agent or the buyer, and in this case, it will be the closing agent, title company, or law firm, needs to analyze every transaction where they're involved and see if the seller is a foreigner, whether because they're a foreign person, they're a foreign trust, it's an LLC owned by a foreigner. And whenever there is a foreigner, they need to withhold 15% of the sale proceeds, okay? Sometimes that 15% can be reduced to 10%. Sometimes it can be completely eliminated. So let's talk about those instances. For example, if the property, it's residential property and it's being sold for $300,000 or less, and the people that are buying it are going to be living there, then the withholding is zero. Right? It doesn't matter what this foreigner bought the property for. If it's less than $300,000 and the people that are buying it are going to reside there, then, and it's residential property, of course, then the withholding can be zero if the sale price is $300,000 or less. If we have a property that is greater than $300,000, but no more than $1 million, and the people and it's residential property, of course, and the people that are buying it are going to reside there, then we can reduce the withholding to 10%. Otherwise, it's 15% of the sale price. So not of the gain, right? It's of the sale price. So that you have an idea. For example, let's say that a foreigner bought an apartment for $100,000 and now they're selling it for $500,000. The person that buys it will not reside in the property, is an investor. So out of the $500,000, there is a 15% withholding. So that means they need to send in to the IRS $75,000. However, if the foreigner bought the property for $100,000 and they invested $200,000, then their gain, or the taxable gain, should only be that extra $200,000. And there are ways to show that to the IRS so that the foreigner doesn't end up sending 15% of the wholesale price, but instead only the taxable amount that's attributed to them. Let's see, I think I have a question. Does the buyer have any responsibility when buying for a foreign seller if the buyer will be residing on the property? So whenever there is a closing, the IRS puts the responsibility on withholding that FIRPTA on the buyer and on the closing agent. If you have a buyer, my advice is require from the closing agent, was the seller a foreigner? If the seller is a foreigner, please send us the documents, right, that you submitted to the IRS together with the withholding amount, because ultimately it could be the buyer's responsibility. And I have seen, we have these issues where title companies sometimes, or law firms even, don't send a withholding amount within the required period. And if they don't, the buyer can be in an issue. So whenever you are with a buyer, I would always ask them, if they know the seller is a foreigner, first to ask, is the seller a foreigner? And if yes, to require from the title company the documentation sent together with the withholding amount to the IRS so that they're free and clear that it was done. If the buyer does the certificate that the affidavit, so they're swearing under oath that they're going to be residing in the property, then they have to reside in the property, okay? So, but it's not, the buyer doesn't have to make it their homestead to be able to sign the certificate. What the regulations require is that the buyer or a family intends to use the property at least half of the time in the first 2 12-month periods. Right, so what does that mean? So if you have a buyer that tells you, I'm buying this as my second home, can I still sign the affidavit so the FIRPTA doesn't apply? Probably yes, because if they're buying it as their second home and they intend to occupy it more than the time that they're renting it, then yes. So for example, if the buyer intends to use the property for 3 months, that's fine, as long as they don't rent it out for more than 3 months. for the next 2 12-month periods, starting the day of the sale. So if the buyer buys it and intends to live there 3 months, no problem. 3 months every year, great. You can still sign the affidavit for the next 2 12-month periods, but you cannot rent it for more than 3 months. You can rent it for 2 months each period, that's fine, but not more than 3 months, because then now it's gonna be an issue, okay? So that's something that the buyer has the responsibility on if they're signing the affidavit. Make sure that they understand all of the consequences, because ultimately, if they sign the affidavit, they get the property and they don't reside there or live there, then they're the ones ultimately responsible for sending the money to the IRS. Because the reason the IRS didn't ask for it is because they said you were going to live there. So you want to be careful with that. All right, somebody's asking me, the retention and rules are the same for commercial properties? Yes, they're the same, and there's no exemption for commercial properties, right? Unless we do something called a withholding certificate, which I'm going to talk about in a minute. Somebody else is asking me, if the buyer decides to sell the property after a few years, do they need to provide for the new sale? Well, if the buyer sells the property after 2 years, then they don't need to provide anything about this. If they sell it within the first 2 years, that might be an issue. You cannot do that. So be careful with that too. All right, so let's talk about the withholding certificate. You can do a withholding certificate in a residential sale or in a commercial sale. So what is a withholding certificate? In order to mitigate the negative consequences that FIRPTA would have on a sale, because I'm telling you it's 15% of the wholesale price, they created a process for us to do something called the withholding certificate, right? And the withholding certificate we use when FIRPTA applies. So we didn't do any other way for FIRPTA not to apply. So this is what we do. We basically tell the IRS that what a real tax liability will be, so that we only pay the tax on that tax liability for the seller. So withholding certificate is an application for reduced withholding based on the gain of the sale instead of the selling price. If 15% of selling price is more than the tax you will owe on the sale, then a withholding certificate may be ideal for you. Important features to know about the withholding certificate applications is if the withholding certificate cannot be applied for or issued prior to the closing, then typically the buyer, right, gets to decide if the funds needs to be remitted within 20 days of the closing or if they can remain in escrow. My opinion is that the withholding certificate needs to be applied as soon as you have a contract, so if that a valid contract, because it's going to take a while for the IRS to respond and say what the actual amount of tax is due. As long as it's applied before the closing, then the withholding agent, in this case, the title company, can decide to hold that money in escrow, right? And then keep it until the IRS sends a withholding certificate back and says, okay, this is the amount that you need to send to us, and the rest you can give back to the seller. If you have a FIRPTA transaction, it's important to put it in the contract so that the title company cannot later say, no, I'm not going to deal with this, right? Because you let them know from the beginning. Normally, during the good old days, the IRS will respond to the certificates within 90 days. However, due to COVID, it's been delayed, and PPP loans and all these things, it's been delayed. So because of that, we have seen withholding certificates come back in 6 months, 7 months, and that's something to consider. If no withholding certificate is done, then what happens is the title company sends this money to the IRS. Then the foreign person needs to file a tax return, right, in order to claim some of it back, in order to claim the refund. And that can take a little bit of time also, but that's what happens if FIRPTA applies. All right, somebody's asking me, after the first 2 12 months period, anything goes? Yes. If your buyer signed the affidavit that they're going to occupy it, and they do after the first 2 12-month periods, they're free to do what they want. Somebody's asking me, there is a lot of confusion on what is a foreign national. Can you clarify? And does FIRPTA apply to a multi-member domestic LLC owned by foreigners? Sure, let's talk about that. So, the first question is, are we dealing with a foreign seller, right? Are we dealing with a foreign seller? And you might think that might be a simple answer, but it's not. It never is. Oh, let me go back to this slide here. All right, assume everybody's a foreigner in Florida. They need to prove you otherwise. So how do they do that? And the title company should be doing this, but anyway. U.S. citizen, obviously not foreigner, because they have a U.S. citizen, they have a U.S. passport, they're U.S. nationals, either born here or they became nationals, even if they don't speak English, not a foreigner. Permanent residents, green card holders, right? Green card holders, either conditional green card holders or permanent residents, obviously not a foreigner. People that have social security numbers, I don't know. We need to analyze how did they get the social. People here on a student visa, foreigners. People here that have a social because they got it long time ago, but they no longer have status, foreigners. Then we have, for example, let's see, LLCs, right? So LLC, single member LLC, owned by a foreigner, unless the single member LLC elected to be taxed as a corporation, and you have that paper that says the election was accepted, right? Or they can show you some tax returns showing that they are in fact paying taxes as a corporation. So even though it's a single member LLC, as long as it's taxed as a corporation and the owner is a foreigner, it's okay. That LLC is not a foreigner, all right? And this is something we can explain to a title company. Single member LLC that elects to be taxed as a corporation, not a foreigner. Single member LLC that made no election and it's owned by a foreigner, foreigner. Multiple member LLC, all owned by foreigners. The multiple member LLC, it's not a foreigner, as long as it has an EIN. So if you have a multiple member LLC with an EIN, FIRPTA the FIRPTA withholding does not apply at the title company level. Now they have other requirements when they do their taxes and they do the distributions, but not at the title company level. Okay, so single member LLC with more than one owner, very important. Multiple member LLC, sorry, I got confused. Multiple member LLC, not a foreigner, as long as they have an EIN, all good. Single member LLC, owned by foreigners, yes, a foreigner, unless they're being taxed as a corporation. Corporations are, even though they're owned by foreigners, they're not foreign and they're not deemed as a foreigner for FIRPTA withholding because they're corporations. So the whole reason why this law was enacted was to prevent foreigners from taking their money and running because they don't have to file taxes. Corporations always have to file taxes. I guess that's why they're deemed not foreigners, even though they're owned by foreigners. Multiple member LLCs, they have to file some type of return, so they're deemed as not foreigners. What other situations do we have? Husband and wife, no. Let's say friends, they own a property, right? So me and my friend from Canada, we own an apartment. Guess what? FIRPTA applies to her part of the property because she is a foreigner. So FIRPTA withholding applies to her 50% of the property, even though I'm not a foreigner. The fact that I own real estate with a foreigner in our personal names makes FIRPTA applicable to her portion. Had we done an LLC and then bought the property, which is I recommend what to do, then FIRPTA would not apply because it's a multiple member LLC, even though one of the owners is a foreigner, all right? So this analysis needs to be done fully, not to miss anything. Trusts, let's talk about trusts. So let's say, let's do actually a scenario that I currently have. Florida LLC, single member Florida LLC, owned by a trust, and the trust is owned by a foreigner. Why? Because the ultimate owner is a foreigner. It's a single member LLC, so it flows through, even though it goes to a trust first, still goes to a foreigner. So foreigner, FIRPTA applies. All right, let's see. Somebody's asking me, does the foreign seller need to file taxes in the United States prior to selling his property or even immediately after he purchases the property? Okay, so let's talk about, I mean, I'm not a CPA nor a tax lawyer, but I am married to a CPA and I do encounter issues regarding that. So that we understand, you have everybody, I don't care who you are, you have to file taxes for any income that you derive in the United States, even if you're a foreigner, right? So if you derive money from the United States, you have to file taxes in the United States. If they're selling property and they're a foreigner and they want to get that money back, they have to file taxes next year. Otherwise, they won't see that money back. So yes, if there's a FIRPTA withholding and they want to see some of that money back, they have to file taxes in order to get the refund back. All right, let's see. Can a person with permanent green card and social security number for working purposes purchase a property owned by a foreigner? If they're a green card holder, they're a permanent resident, right? So if they're a green card holder or a permanent resident, they can sign the affidavit saying they're going to reside in the property. Yes, they can. because green card holders, permanent residents have the right to reside here. If the buyer is another foreigner, they cannot sign that because they don't have the legal right to reside here. So very important. The buyer has to be a US person that is going to reside here. Somebody's asking me, what if the trustee is a national? Is it still a foreigner? Okay. So what we care about the trust is not who the trustee is so much, is the beneficiary. So if the ultimate beneficiary is a foreigner, then foreigner. If the trustee is a US national, but the ultimate beneficiary is a foreigner, foreigner. It's a foreign trust. All right, let's keep going. Sometimes we can do 1031 exchanges to sometimes deal with this withholding amount. So let me give you a quick overview of what 1031 exchange is. If I buy property for investment purposes, I can sell the property, and instead of paying taxes at that moment, by using somebody called a qualified intermediary, which is essentially an entity or person that holds all of the proceeds, so I never touch them, they can then put that money in a new property that I purchased also for investment purposes, and I don't have to pay taxes at that moment. The tax is in fact delayed. The taxes for the gains, I don't have to pay them. And US people use this a lot to keep on acquiring property, right? So whenever you sell a business or invest in property and you have a gain, you generally have to pay tax on that gain at the time of the sale. The IRS section 1031 of the US tax code provides an exception and allows you to postpone paying tax on the gain if you reinvest the proceeds in similar property as part of a qualifying like-kind exchange. However, gain deferred in a like-kind exchange under the IRC section 1031 is tax deferred. It's not tax-free, it's just a deferral. The exchange can include like-kind property exclusively, or it can include like-kind property along with cash, liabilities, and property that are not like-kind. If you receive cash, relief from debt, or property that is not like-kind, however, you may trigger some taxable gain in the year of the exchange. There can be both deferred and recognized gain in the same transaction when a taxpayer exchanges for like-kind property of lesser value. So who qualifies? Owners of investment and business property may qualify for a Section 1031 deferral. Individuals, C corporations, S corporations, partnership, general or limited liability companies, trust, or any other tax-paying entity may set up an exchange of business or investment properties for business or investment properties under Section 1031. Now, for foreigners, it works a little different, because if they do a 1031 exchange and the property's in their name and FIRPTA applies, they're gonna have to put the money equal to the FIRPTA in the title company's funds until they receive the withholding certificate. And at the same time, all of the proceeds need to go into the purchase of the new property. If they weren't foreigners, then that way 1031 exchange works is you sell the property, but you don't touch any of the money. All of it goes for the purchase of your new property. However, when you are a foreigner, you still have this FIRPTA withholding if it applies, and the title company needs to keep that in their escrow account until they receive the withholding certificate from the IRS saying that no tax is due. And the withholding certificate that we would send to the IRS would say that no tax is due because you're using a 1031 exchange. So if we're doing 1031 exchange, what the foreigner has to do is come out of pocket, deposit the amount equal to 15% withholding with the title company until they receive the withholding certificate that no tax is due because of the 1031 exchange, and then the foreigner should be able to get all of their money back. So foreigners can still do 1031 exchanges, not to pay the taxes at that moment to defer them. It just works a little different if FIRPTA is involved, because the title company needs to have that in their escrow account until they receive the withholding certificate back. And the withholding certificate will be applied for saying that no tax is due because we use 1031 exchange. I know it can get a little complicated. That's why you need to work with us or a knowledgeable attorney and CPA to make sure all of this goes through smoothly. Let me see if we have any more questions. Okay, 1 second. Somebody's asking me, is it okay for foreign sellers who bought property in Florida as joint tenants with rights of survivorship transfer title to a corporation prior to putting it on the market for sale to avoid FIRPTA? Okay, let's kind of explain that a little bit. You can never do anything to trick the IRS from this withholding. And we have to be really careful with that, right? So if you have a property right now that it's owned by a foreigner in their own name, and you come to me and tell me, Romy, we want to sell this property next month. Can you please transfer it to a corporation so that we don't get FIRPTA? No, because now you're doing something to trick the IRS right before. However, had you, before you bought the property, done it, no problem. Or if you want to do it now, that's okay, but don't sell it next month. You know, might be able to sell it a year from now or 2 years from now. That's fine too. You're planning for the future. But you never want to be seen as you're doing something to trick the IRS because you cannot hide from them. So I would advise people to plan before you buy, or if you find out you need to do this planning, that's fine, but don't sell right away. You don't want to have any issues with the IRS. Somebody's asking me, for the IRS, do we have to, for the 1031 exchange, do we have to buy property within a certain period of time? Yes, within 180 days. So you want to make sure that you bought the property and closed on it within those days, because there is no extension. And we can discuss that particular case when 1031 is applied, dealing with a foreigner in detail, because it can get really complex, and we want to make sure that we abide by all the rules. All right, I want to talk to you guys about state tax, okay? Us as US people, we have an exemption of, I think, 12 million or something. So unless you're really rich, you don't have to worry about it. But foreigners don't. Foreigners usually have an exemption of only $60,000, okay? So foreigners in America who acquire US assets and then leave the US and continue to own those assets, they need to be aware of federal state tax rules, okay? The US imposes a 40% state tax, right? That is a state tax rate, 40% on US assets above a $60,000 exemption thresholds on assets of the deceased foreigners. So foreign states become subject to US state taxation with respect to their US situated assets. US situated assets include American real estate, right? So definitely Florida property, tangible personal property, and securities of US companies. A non-resident stock holdings in American companies are also subject to state taxation. So if you think that a foreigner owns an LLC and the LLC owns the property, they avoid state tax, that is not correct. That membership interest in the LLC, that participation in the corporation, the stock in the corporation, that would have to go through probate, and it's subject to state tax, okay? Certain assets are exempt from US state tax, which include securities that generate portfolio interest, okay? Bank accounts not used in connection with a trade or business in the US, and insurance proceeds. The state of a non-resident alien may deduct from the gross state value of property passing to the decedent surviving spouse if the spouse is a US citizen or resident alien, regardless of whether the spouse lives in the US or abroad. However, if the spouse is also non-resident, then they need to further plan. Effective tax treaties, there's a limited number of countries that have state tax treaties with the US that eliminate certain types of assets situated in the United States from the 40% state taxation. Only the following countries, as of that I know of, have treaties with the United States. Those are Austria, Denmark, Finland, France, Germany, Ireland, Italy, Japan, Netherlands, Norway, South Africa, Sweden, Switzerland, and the United Kingdom. But even for those countries, there's a reduction in tax. It's not a complete exemption. So foreigners having US property, foreigners having interest in LLCs, interest in corporations, they're going to be subject to a 40% state tax. There are ways to plan so that the state tax, it's not due, right? So one of the ways is, for example, and this of course doesn't apply to everybody because every situation is different. But let's say that a foreigner owned Florida real estate through an LLC, and the LLC was owned by the foreign company. In that scenario, even if the foreigner dies, nothing really happens here because the Florida LLC still continues to exist, and it's owned by a foreign entity, and the foreign entity still continues to exist. So there is no probate required, no state tax due. That's one simple planning tool that might work for some people. Every case is different. So we like to sit down with the client, see their US assets, what do they have, and how we can work around so as not to deal with probate and so as not to have to deal with this 40% state tax. So which entities are best for foreigners? I mean, that depends. Single member LLCs, one, this applies for everybody, by the way. The law changed in January of 2015, and single member LLCs don't offer the same liability protection. So I technically don't want to form them for people unless there's a specific reason. These are Florida single member LLCs. Delaware single member LLCs, South Dakota single member LLCs still have the protection. This is just a little wrinkle that we have in Florida. Multiple member Florida LLCs, full on liability protection. However, remember that single member LLCs don't protect you from FIRPTA unless you elect to be treated as a corporation. One key fact, you don't need a U.S. address to form an LLC. What is required for foreigners is to have a U.S. registered agent. Okay, I usually recommend LLCs for real estate purchases. For foreigners, it's a little examination whether they understand that if they own LLCs directly, they may still be they're going to be subject to the state tax, and they may need to file a U.S. tax return personally in the United States for any income or any distribution money received from the LLC. So sometimes they want to form corporations instead because they tell me, Romy, we're not going to get any distribution. If that's the case, and the corporation owns the Florida property, and then the corporation files a return here, but no problem, because with the personal tax return, as long as the foreigner doesn't receive any distribution, sometimes we form a Florida LLC owned by the foreign entity, and then they understand that the foreign entity will need to file a tax return here from any money they receive from the Florida LLC. So it can be a little complex. We like to sit down with the foreigner. I also like to bring in the CPA so we can advise both on the legal perspective and also on the tax perspective. And at the end is the client's responsibility and decision what they want to do. I had clients tell me, Romy, I don't want to deal with Florida entities. I don't want to deal with foreign entities. But I want to do something not to leave my kids with this huge state tax. What can I do? So sometimes I tell them buy life insurance. So that way, whenever you pass away, the life insurance will cover whatever tax liability will fall on your kids, and then they can still get the property free and clear. And that's actually worked out for a couple of my clients, the life insurance part. So there's different ways to plan and to structure things. The important thing is that they're aware, so it doesn't hit them by surprise. I recently had a case where we are going to end up paying 40% state tax for a state of over 3 million. Can you imagine how much that is? So please plan. Tell your clients, I don't expect you to do the plan for them. They need to sit down with an attorney, with a CPA, and come up with something so they plan for the future so that this, American dream doesn't become a nightmare. All right. Another thing that I like to discuss with my foreign clients. Oh, wait, I have one question. Somebody's asking me, the purchase price for the next acquisition, does it need to be greater? It can be the same or greater than the property that you sold. All right. Another thing that we have for the clients that no other country has, it's called title insurance. Title insurance, it's really a nice protection to have, and a lot of clients are not familiar with it because they're like, what is that? So if you're purchasing real estate, you're likely purchasing from somebody who's reselling it. You may not be the first person to conduct a real estate transaction with that property. In fact, the title to the property you're purchasing has likely changed hands many times. The land the property is located on may have changed hands even more times. All too often, small details in title transfers can be overlooked. When this happens, it causes a potential problem in the validity of title to the property. At some point, liens could have been overlooked or signatures could have been forged. Any mistakes along the way can easily come back to haunt you, even if your purchase of the property was otherwise completely legal and performed correctly. Title insurance helps ensure the value of your title in case one of these errors jeopardizes your property. Unlike traditional property insurance, title insurance protects against mistakes in the past. An owner's title insurance typically covers losses up to the amount of the purchase price. So what can you protect? You're going to be protecting your house for the future, but the protection starts the day that you purchase it. So you want to make sure that your clients understand that title insurance, it's not an election, even if they're buying cash, they need to get title insurance. It protects, to defend title against anybody that claims they had ownership in the property, that a deed was forged, the taxes were not paid, that, they don't have access to the property, that they were unpaid mortgages and other liens, that there were easements or rights or ways that limit the use of the property that were not disclosed, or anything that makes title non-marketable. All of that title insurance will protect against. And that's a really good selling point because in other countries, we don't have title insurance. I remember, and I tell my realtor friends this, that the first time I went back to Peru after a long time of not being there, I would see properties with writings on them saying, not for sale, and a phone number. And to me, that was really weird. I'm like, why are you saying your property is not for sale? And then you put a phone number. And then they explained to me that it was customary that people will try to say that they own the property, sell it to you, and then you would end up paying them money and you wouldn't own the property. And I'm like, how can that be so? And they explained to me that, there's a lot of fraud. And I asked them, well, how about title insurance? And they're like, what is that? We don't have that here. Here, we do have title insurance. Basically, we researched all the way to the time where alligators used to occupy the lands in Florida to the moment that you get it. And this protection is fabulous because it protects from anything that could have happened during that time. So that when you get the property, you're getting it, clear and free. And if anybody else comes to make a claim on it, you can come after your title insurance. You can come after that policy. Now, one thing, and I had this recently, to be careful of, people that are buying cash especially. People sometimes try to, save money in the most inefficient ways. One of those ways that I've seen is people are like, no, I don't want to do a survey. I can see my property just fine. That's a big no-no, even if you're buying cash, because title insurance will not protect you against something that would have been disclosed by a survey. Okay, and what could have been disclosed by a survey? Well, something that could have been disclosed by a survey is your future neighbor decided that his boat was too big and that he wanted to make the fence in your property, right? So in reality, your property ended here, but your neighbor's boat, he made the fence and it ends here. You're never going to be able to see that with your naked eye unless you do a survey. So we actually had a case like that. And I'll tell you about it a little bit so that you can tell your clients to get title insurance. This person bought the property, didn't do a survey, they bought it cash. Then they decided that they wanted to sell the property. They enter into a contract, they're about to close. But of course, the buyer was buying this with a mortgage, with a loan. And what's the first thing the mortgage loan says? Do a survey. So the buyer did a survey and it showed that the neighbor was basically occupying this person's land for, space because of their boat. So now they told the buyer, we're not going to give you that loan unless that's corrected. So the buyer told the seller, hey, your neighbor is basically occupying your property. Of course, what is the first thing that the person do? The seller, they went after the realtor. They're like, oh no, my realtor didn't tell me. Do a survey. Your realtor doesn't know either. You can't see it. So now they came to us asking me what they can do, if they can go after a title insurance policy. I told them no, because the title insurance will exempt anything that could have been disclosed via a survey. So they cannot come after a title insurance company. All they could do is basically ask their neighbor to fix their fence or sue them. So now they have to sue them. They have to invest in attorney's fees, wait it out. And the neighbor could say that they were occupying the property and that therefore they have an easement. So now they're not going to move their boat. I mean, this can turn out really ugly. So at the end, the deal to sell the property fell through because, of course, the buyer didn't want to wait. And this person ended up with that problem. So avoid that. Whenever you have a client that's buying cash, I don't care. They need to get title insurance. And also, they need to get property insurance. That's another one. I've seen this maybe like 5 times already, where foreigners, they buy cash and they decide not to get liability insurance, not to get any property insurance, even though we live in a hurricane, so not to get anything. They rent out the property, the tenant gets injured, and now they sue them, and the property is bought cash, so the attorneys are super happy about that, and now they can come after the whole property and basically take it. So if foreigners are buying property, even if it's cash, they need to do a survey, they need to get insurance. That's just protection for them. All right, let me see. I think I have more questions. I don't see. Okay, here we go. Oh, somebody's saying it's amazing. Thank you, Eva. I appreciate it. All right, let's see. Hi, normally the title company checks all the information before closing a transaction. In the case, can we omit the title insurance? No, Do not omit title insurance. Always get title insurance, and don't trust anybody, because guess what? Whenever you make a title insurance claim, you're coming after the title company and you're coming after the insurance company who didn't check something or something wasn't able to be discovered. So you want to make sure that you get title insurance, and you want to make sure you work with a reputable title company. Absolutely. Always title insurance. It's a wonderful thing that we have in this country. No other country has it. So let's use it. And it's not that expensive, and it's set by Florida statute. So regardless of what title company or law firm you go to, they have to charge you the same thing for title insurance. All right, now let's talk about something that's coming to us on July 1st. Is this new regulations that were already approved, and now they're going to restrict ownership of certain foreigners, okay? Now, bear with me on this. This just came up, so I don't have a lot of information, but I'll tell you what I know as of now. This might change come July 1st, and I'll do another webinar. But as of now, this is the information that we have, and that is important for our clients to know, because it may affect them, and for you guys to know, because it may affect your business also. So, the Florida legislature recently passed Senate Bill 264, SB 264, which was signed into law by Governor Ron DeSantis on May 8, 2023. This law introduces new regulations affecting individuals or entities from specific foreign countries, including China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria. So for you guys that have foreign clients from China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria, listen up. Or that have had clients from there, listen up. SB 264 has several key provisions. There is a prohibition on government contracts, right? So Florida government entities are not allowed to enter into contracts with any of the mentioned foreign countries. There is a prohibition on economic incentives. Government entities in Florida cannot provide economic incentives through contracts or agreements to any of the foreign countries mentioned. There are restrictions on land and assets ownership. Here's where we need to pay attention. Foreign principals from the listed foreign countries are prohibited from owning agricultural land and certain asset classes such as real property near military installation or critical infrastructure. Okay, let's listen to that again. These are the restrictions on land and asset ownership. Foreign principals from the listed foreign countries, so China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria, are prohibited from owning agricultural land and certain asset classes such as real property near military installations or critical infrastructure. Strict restrictions on Chinese foreign principals. The law imposes even more significant limitations on ownership by foreign principals from China. Okay, so now let's talk about and let's delve into it. And again, this is what I know now. Everything might change. All right. So what do I mean by restrictions on agricultural property? Prohibition on foreign principals from directly or indirectly. Okay, this is important. Prohibition of foreign principals from directly or indirectly owning, having a controlling interest in, or acquiring agricultural land or any interest in such land except for a minimal and direct interest. Minimal and direct interest refers to a minimal level of ownership or control that foreign principals can have in agricultural land. A foreigner meets this criteria if they own registered equities in a publicly traded company that results in ownership of the agricultural land, their ownership interest in the company is less than 5% in any class of registered equities, or less than 5% across multiple classes of registered equities. Alternatively, they may have a non-controlling interest in an entity controlled by the company registered with the U.S. Securities and Exchange Commission as an investment advisor under the Investment Advisors Act of 1940 and is not a foreign entity. Other than that, they cannot own agricultural land. Exemption. Agricultural land owned before July 1st, 2023 is exempt from the restrictions. However, to own agricultural land after that date, right, that will not be exempted. Now, there is a registration requirement. This is so important. We have foreigners from those countries that I mentioned, and they had agricultural land. They need to register because the penalty for late registration is $1,000 for foreign principal who failed to register their ownership, right? They could also be a lien on unregistered land. The Florida Department of Agriculture and Consumer Services can place a lien on the unregistered agricultural land to recover the unpaid penalties. Buyer affidavit requirements. Buyers of agricultural land must provide an affidavit confirm that they are not foreign principals. Non-compliance with these requirements does not impact the land's title or insurability. Consequences for violating the ownership of agricultural land restrictions are, so one, we need to remember, if we have foreign clients that own agricultural land before July 1st, they need to register. I didn't find the registration form just yet, but when I do, I will work with clients to register. People that are buying this in the future, they cannot be foreigners from those areas unless they own a very minimal interest in registered securities as discussed. Consequences for violating the ownership of agricultural land restrictions include land forfeiture to the state, so bye-bye property, civil action by the Department of Agriculture for forfeiture, recording of a lease pendants, meaning a notice of legal action that puts a lien on the property, final judgment of forfeiture transferring the title to the state, sale of the land that was subject to forfeiture, and possibility of an emergency seizure if the state sees a clear and immediate threat. SB 264 does not provide a specific definition of agricultural land within the text of the bill. However, agricultural land generally refers to land that is used for farming, raising livestock, or producing crops. Example of agricultural land may include crop fields, land used for growing crops such as corn, wheat, soybeans, or vegetables. Orchids, land used for growing fruit trees such as orange groves, apple orchids. Vineyards, land used for growing grapes or wine production. I love wine. Pasture land, land used for grazing livestock such as cattle, sheep, or goats. Poultry farms, land used for raising chickens, turkeys, or other poultry. Dairy farms, land used for raising dairy, cows, and producing milk. Aquaculture facilities, land used for raising fish or other aquatic organisms for food. Keep in mind that the specific definition of agricultural land may vary depending on local regulations and zoning laws. So I don't have that definition within the bill. So this is just to give you an idea. Military, there is a prohibition for foreign principals to directly or indirectly own, have a controlling interest in, or acquire real property within 10 miles of a military installation or a critical infrastructure facility in Florida, except for minimal and direct interest. The exception is that the exception allows foreign principals to continue holding an interest in such properties if they own the property directly or indirectly before July 1st, 2023. Additionally, registration requirements are established in this case. The registration needs to be done with the Florida Department of Economic Opportunity rather than with the Department of Agriculture. The bill also imposes civil and criminal penalties similar to those described above for violating these provisions. I don't have the registration forms just yet, but when I do, I will let you know. What is the critical infrastructure? I don't know just yet. But we will research because this is new, this is ever development. So we just want to be sure that our clients are, complying as much as they can. There is a special restriction against people from the Republic of China, okay? And this is a special restriction. The other restrictions that we discussed applies to all the other countries that I mentioned, but there is a special restriction from people of China. Hold on, I think I have a comment. All right, somebody's asking me that they received a letter from an attorney saying that they were not allowed to buy in certain cities. I'm sorry, send me the email or letter from the attorney and I can research. This evaluation, it's gonna be really case by case, okay? It's gonna be case by case because I need to see what a civil infrastructure is, or I need to see what country they're from. I need to see how close they are, the radius. Listen, I don't want to scare people, but we do need to be diligent with our clients, and it is a person by person information. So I'm going to put in my contact information in the chat so that everybody has it. And then we can definitely sit down with the clients and discuss all of their situations. So my phone number is 305-921-0976. My email, it's romy@jurado, Jurado, law, LAW, firm.com. I'm also extremely, available through Instagram because it actually comes directly to me. And my Instagram is my name, Romy Jurado. So feel free to follow me and message me through there. I know that this law, it's very important for our clients from those countries to read and analyze, and I am more than willing to sit down with them, look at the property that they have, see how close it is to certain things, and see if they need to register, if they don't need to register, what they need to do, and help them comply. If you're helping people from this country acquire property, we can represent them, of course, in the closing all over the state of Florida, but more importantly, we can represent them to assess how these laws affect them. Can they buy? Can they not buy? What can they do? All those things, we're more than willing and able to help. So please feel free to reach out to me. Our phone number is 305-921-0976. My email is romy@juradolawfirm.com. And my Instagram is Romy Jurado, my name, ROMYJURADO. And I would love to help you and your clients. All right, so now let's talk about, let me see, and I put it in the chat there. Let's see regarding China. So there's a special prohibition to purchase or acquire real property in Florida by specific individuals or entities primarily related to the People's Republic of China. The following groups are not allowed to directly or indirectly own, have a controlling interest in, or acquire real property in Florida: the People's Republic of China, the Chinese Communist Party, or any official or member of this group; any political party, member of a political party, or subdivision of a political party in the People's Republic of China. Sorry, I need a little bit of water. Partnership, associations, corporations, organizations, or other entities organized under the People's Republic of China, laws, or with their principal place of business in People's Republic of China or subsidiaries of such entities. Individuals domiciled in the People's Republic of China who are not U.S. citizens or lawful permanent residents. Persons or entities with a controlling interest in any legal entity or subsidiary formed for the purposes of owning real property in Florida as described in subparagraphs 1 through 4. Exception: despite this property ownership restriction, a natural person is allowed to purchase one residential property up to 2 acres in size, provided that the parcel is not on or within 5 miles of any military installation in Florida. The person has a current verified U.S. visa allowing legal presence in Florida, and the purchase is in the name of the visa holder. That's the exception. A registration is required with the Department of Economic Opportunity. Additionally, the buyer of real property must submit an affidavit under penalty of perjury, confirming that they're not a person or entity listed above and are in compliance with the requirements. Failure to comply with this requirement does not affect land title or insurability. Violations of this provision may result in civil and criminal penalties. So again, this is an ever-changing law. We need to help our clients comply, and I am more than willing to help you guys do that, and ladies do that. It comes into effect July 1st. And for those that own property beforehand, there is a registration requirement if they're from those countries. And once the forms are available, we can help them comply with that too. My contact information is there on the screen. My presentation is over now, but I want to thank all of you guys for attending today's class. If you have any questions, please feel free to reach out. Again, my name is Romy Jurado. I'm a licensed Florida attorney. In my firm, we do immigration all over the United States, trademarks and copyrights federally, so all over the United States, business law, real estate, state planning and probate, all over the state of Florida. We're fully bilingual and we're here to help. Thank you again. I hope you enjoyed the presentation. Bye-bye.